May I please, Your Lordship. Please allow me to mention hearing item 15.
Hearing item 15.
Yes, my lord. On behalf of Sir Ali Sheikh, since he is off season and indisposed at the moment, I pray the matter be listed after 2 weeks.
It is a fixed item otherwise.
Yes.
Learned counsel for the petitioner, Mr. Pakring Chapu, who has made a mention on behalf of the leading counsel, Mr. Sohor Ali Sheikh, who is indisposed today. Accordingly, this is a matter after 3 weeks.
For 2 weeks, my lord.
Learned, government advocate and Nangami is present for respondents. Yes.
I will back, my lord. May I please, my lady? My lady, I beg to mention for listing of a case I have filed this morning, along with item number 22 of sublease to this list. There is a bit urgency.
Along with 22.
22, my lady. Obliged.
Ma'am, please, my lord. Lord, I beg to mention item number 11, hearing item number 11. I'm for a respondent, my lord. I pray that if this matter could be adjourned for next week, my lord. This petitioner is having some personal difficulty.
Lordship, let it be fixed as the first hearing item. On 26.
Okay. Heard learned counsel for the respondent, Mr. Such and Such, mentioning on behalf of Yangarwati, learned CGC. It is stated that the learned CGC is indisposed today, and accordingly prays for listing the matter on matter next week.
Yes, my lord, next week. As per the convenience of the court.
Next week in the hearing list. Did it come? Let's see.
Obliged, my lord.
May I please, Your Lordship, may be pleased to mention item number 8, 9, and 10. And then, Your Lordship, if the matter can come up after vacation, Your Lordship. 8, 9, and 10.
This is a petitioner.
Yes, I'm for the petitioner, my lord.
Heard learned, government advocate, Ms. Livika, who prays for listing the matter after the summer vacation. So learned counsel for the petitioner has no objection, list after the summer vacation.
Your Lordship, I also want to pray for item 12 of also.
Item 12,
After vacation, Your Lordship.
item 12, same order.
Lordship, item 12, there is some urgency. Lordship. We can make an attempt.
Today, you know, Your Lordship, because I also have the, they gave additional reply to my additional affidavit, Your Lordship.
That is long back.
No, Your Lordship, only on the last occasion only I received. However, Your Lordship, I'm not prepared today, Your Lordship. Let it come after vacation, Your Lordship.
Next week, can we try next week?
Your Lordship, after.
You're saying there's a, what's the urgency?
It's an upgradation, Your Lordship, that they are paying, they are asking for a scale pay, Your Lordship.
Oh,
Similar scale pay, so there is no urgency in fact, Your Lordship.
Since 2014, our similarly situated persons are enjoying the higher pay scale, and we are deprived of that. By filing counter affidavit, the government is trying to improve their case.
Let's try next week then if.
Your Lordship, the following week then.
That is
Next week
vacation,
is the last
vacation.
week.
Only next week is the working
First
week.
Working week.
Your Lordship, then on Thursday, we'll make an endeavor.
Thursday.
Next week, Lordship, I have some difficulty, that's why. If it is convenient to the honorable court, then we would
Opening
like
day
to.
then, opening day,
No problem,
14th July.
no problem.
Yes, on 14th July.
Much obliged.
Yes.
May I please, Your Lordship? Your Lordship, I'd like to mention hearing item number 13, Lordship.
Yes.
If this matter can come up on Monday, Lordship. 13.
You are for
I'm for the respondent on behalf of PP Paul.
learned counsel for the respondent number,
Private respondent.
private respondent, Sri such, mentioning on behalf of Mr. P.P. Paul, has prayed for listing the matter
On Monday, Lordship.
on Monday. It's okay. On Monday. Give a date, okay? 23rd. Yes, on 23rd. Learned counsels for the petitioner is present. Has no objection, list on Monday, 23rd. Yes.
Obliged, Lordship. Lordship, I have similar prayer for item number 20, Lordship. Here we are yet to file our affidavit in opposition.
Item
20, Lordship.
20.
We are here yet to file our affidavit in opposition, Lordship. So
Item 20, learned
Yes.
counsel for the respondent submits that the respondents are yet to file the affidavit in opposition and accordingly prays for
2 weeks, Lordship.
2 weeks' time to file the affidavit in opposition. Learned counsel for the petitioner is present. There's no objections, list after 2 weeks.
Obliged, Lordship.
Yeah, please, your lordship. Lordship, I beg to mention hearing item 16, 17, and 18. On behalf of Mika HIA for respondent 7. This matter may kindly be listed after the vacation.
For respondent 7,
Yes, lordship.
No objection, Lordship.
learned counsel, speaking on behalf of Mika A for the respondent number 7, has prayed for listing the matter after the summer vacation. The counsels for the petitioner, learned counsel for the petitioner has no objection, list after the summer vacation for hearing.
Please, your ladyship. I beg to mention item number 19.
19.
My senior has some personal difficulties today, so if the matter may come up after the vacation.
Item 19, mention has been made on behalf of
Mr. AZ Momi.
okay, counsel for the petitioner, Mr. A. Zimomi, that the council has some personal difficulties today and accordingly to list the matter after the summer vacation.
Yes.
Yes, prayers allowed. Learned counsel for the petition, respondent,
Number 2 and 3.
number 2 and 3 is present.
Present.
Government advocate. Such government advocate, such is present. List the matter after the summer vacation.
Please, your lordship. Your lordship, this matter, the same matter is listed today in family court in Dimapur. We have received information that both the parties have compromised. However, we need further to seek further instruction to be placed before the
Which
court.
item?
Item 1, your lordship.
Item 1.
Yes, lordship.
Okay, out of court settlement.
Yes, your
Out
lordship.
of court. Item 1, admission. It
Item
is-
1.
Yes, it is submitted by the learned counsel such and such appearing on behalf of, you are for the petitioner,
For the respondent, your lordship.
appearing for the respondent, and who's for the petitioner? Appearing for the respondent has submitted that the matter has been settled amicably outside the court. And accordingly, some instruction is required for the same and prays for listing the matter when,
1 week.
after 1 week. List after 1 week. Petitioner,
Yes, Your Lordship, I am Jin.
they're asking for 1 week time.
Yes, in fact, the matter is listed today in the family court.
Yes, yes.
So there may be an
Okay,
outcome.
okay. So learned counsel for the petitioner has no objections to the same.
Much obliged.
Okay.
May I please, my lady?
Yes,
I beg to mention item number 4.
4.
Yes, my lady. My lady, it appears from the records that service upon respondent number 10, 11, and 12 is still awaited. So I pray the matter be listed after the vacation.
10, 11, 12.
Yes, my lady.
You have checked the records.
Yes, yes. Yes, my lady.
Item 4, learned counsel for the petitioner, Sentilong submits that the notice on respondent number 10, 11, and 12 is still awaited. Accordingly, prays for listing the matter after the summer vacations. Prayers allowed. Learned counsel, we should pray for respondent number
3, 4, 5, 6, 7, and 8.
is present, and learned counsel Shri N. Angami is present for respondent number 1. List after summer vacation.
Much obliged.
For motion from the supplementary cost list, item number 21.
Please, your lordship.
Yes,
Your Lordship, this is a condemned petition for non-compliance of this honorable court order in WPC 141 of 2020.
Let's see the court's direction. Is that
Your Lordship, it is in Annexure A.
Annexure A, the operative portion?
Paragraph 29, Your Lordship.
Compassionate appointment
Lordship,
shall be completed by the, say, within a period of 2 months. Learned counsel for the petitioner, Ms. Such and such. So this is an application under section 12 of the Contempt of Courts Act 71, read with Article 215 of the Constitution of India, alleging willful and deliberate non-compliance of this court's order dated 12/11/2024, passed in WPC 141 of 2020, by which the state respondents were directed to consider the case of the petitioner for compassionate appointment within a period of 2 months from the date of receipt of the order of the court. So it is submitted that till date, the respondents have not complied with the direction of this court, and hence the present petition. So, issue notice issue notice to the respondents number 1, 2, 3, and 4, returnable within 4 weeks. Stop. The petitioner shall take steps by registered post as well as usual process within 3 working days from today. List of the forms.
oblige Your Lordship.
For admission, item number 2.
Please, Your Lordship.
Yes, Livika, can we dispose?
Yes, Your Lordship. Yes, Lord.
Let's see what instructions. These are just an investigation.
Yes, yes,
investigation.
that is what I received. The status, the first one that I submit was the status report
Mm.
of the IO. As per the status report, they just informed that there was an amicable settlement only,
Yes.
only to that extent.
Since the petition is filed by both.
Yes,
the
yes.
accused and the complainant. Okay. Third learned counsel for the petitioner, Mr. P.D. Nair,
GLM.
or GLM. as well as Ms. Livika, learned BP for the state of Nagaland. This petition has been filed under section 528 of the BNSS, praying for quashing of the FIR dated
Page 18, madam. Lordship will find in my cost title also, madam, at page 1 of first page.
that,
First page, madam, page 1, madam.
I guess,
Suburban PS case number.
quashing of the FIR in suburban PS case number 21/2025 under section 318 clause 4/316 clause 5 of the BNS. Stop.
And consequential proceeding, madam, GR number, madam, 180. Next page.
And the proceedings in GR number 180/2025 pending in the court of the learned CGM Dimapur,
Yes, madam.
Nagaland. Stop. It is the case of the petitioner, next paragraph. It is the case of the petitioner that the petitioner 1 had lodged an FIR against the petitioner 2 in the suburban police station Dimapur, alleging that on 15/8/2024, he had entered into an agreement with the petitioner number 2 to open a dealership of his business at Dimapur, and he had given an amount of rupees 15 lakhs to him with a promise that in default, he shall return the amount within January 2025 without fail. It was also alleged that after entering into the agreement, the petitioner number 2 started to ignore his calls and failed to repay the said amount in spite of constant reminders. And therefore, he prayed for recovery of the money from the petitioner number 2. On the basis of the FIR, suburban PS case number 21 of 2025, under section 318 clause 4/316 clause 5 of the BNS was registered against the petitioner number 2 on 26/4/2025 and was registered as GR number 180 of 2025. Stop. In the meantime, next paragraph. In the meantime, the petitioners 1 and 2 have already settled their differences and resolved their disputes via deed of compromise dated
No, page dated on 13/5/25. But page 26, madam.
that compromise is
Page 26.
page 26
Yes, madam.
by a deed of compromise dated 13/5/2025. The deed of compromise was executed between the petitioner number 1 and the brother of the petitioner number 2, as the accused was in custody at that point of time. Stop. The deed of compromise has specifically stated that the first party had received, the first party / petitioner 1 has received the entire amount from the second party / petitioner 2, and there are no outstanding dues, and as such, the first party will approach the court or police authorities to withdraw the said FIR. Stop. In view of the said, in view of the aforementioned deed of compromise, the petitioner 1 and 2 being the complainant and the accused respectively have filed the present petition, praying for quashing of the FIR as well as the consequent proceedings before the learned judicial magistrate Dimapur.
Chief Judicial Magistrate.
Chief Judicial Magistrate Dimapur. Stop. Next paragraph, Learned PP, Ms. Livika has produced the
Status report.
scanned copy of case diary and also the status report. In the status report, the IO of the case has also mentioned that they have been informed that a compromise deed has been made between the accused and the complainant. And it has been stated that the issue between him and the complainant has been amicably settled. So. Next paragraph. In view of the facts and circumstances as mentioned above, and in view of the deed of compromise dated 13/5/2025, this court is of the view that it will be a futile exercise to continue with the proceedings before the learned Chief Judicial Magistrate Dimapur, Nagaland, in as much as it would not lead to a conviction. So accordingly, the petition is allowed and the FIR in suburban PS case number 21/2025, as well as the proceedings of GR number 180/2025 before the court of learned CGM Dimapur are quashed and satisfied.
Obliged.
Much obliged.
Petition disposed. Petition disposed.
Obliged. For orders, item number 3.
Lordship,
Complaint.
yes. By this order, we have written to all the divisions to convert the fixed pay to scale of pay. So, my lady, I pray that based on this letter,
You've
the matter may be
received the
closed.
copy.
Yes, Appraisal Lordship. Yes, Lordship, petition may be closed,
Yes, sir.
and these two letters issued by the ANC, Engineer in Chief, may be placed on record, Lordship,
Yes.
because I have yet to get the minimum pay scale, despite the fact that instruction has been issued by the Engineer in Chief.
This is March, actually.
Yes,
So now
and the
we're-
second one is May.
Oh, okay. Fixation of pay upon conversion of fixed. The direction of this court. Page.
Page 19, Lordship. Operative part, page 22.
This is for scale pay, isn't it?
Yes.
You're applying for
Minimum scale of pay, yes.
At the outset, the learned counsel, Ms. V. Shukre, appearing for all the respondents,
Yes.
for all the respondents, has produced a copy of the letter number capital E dash IN dash C slash ESTT dash 9 slash fixed slash 2024 dated 17th March 2025, and a letter, no, this will be written by the Engineer in Chief NPWD Nagaland to all the chief engineers, the SEs and the EEs under the Nagaland PWD, directing them to convert all the work charge and casual employees in all the departments who are receiving fixed pay to be granted scale of pay as per the revision of pay 2015 with effect from 1/4/2025. So the learned counsel has also produced a copy of the letter number E-IN-C slash ESTT dash 9 slash fixed slash 2024 dated 27th May 2025, written to the Chief Engineer, PWD slash RNB slash housing slash mechanical slash National Highway slash Chief Architect PND in brackets Nagaland from the Engineer in Chief NPWD Nagaland, Kohima. Under the subject fixation of pay upon conversion of fixed paid work charge and casual employees. Stop. It has been directed by the said letter to carry out the fixation of pay by the chief engineers of the various departments. Stop. In view of these aforementioned letters, it is seen that the direction of this court in WPC 86/2022 directing the respondents to grant scale pay to the petitioner has been complied with. Stop. Learned Counsel. Before that, you say the above mentioned letters are kept on record and marked as X. Okay. And next para, Learned Counsel for the petitioner, Shri Wati Jamil, has no objections if the matter is closed. Stop. In view of the above letters and in view of the fact that the order of this court has been complied with, this petition stands disclosed.
Much blood.
It's closed and disclosed.
For orders, item number 5.
May it please my leadership. Here, this honorable court has directed the respondent to pay the time-bound scale of pay to the petitioner. And I've been instructed that time-bound scale has been paid to the Division of Housing and to the RNB only to the Division of Twinsan. So I need a further instruction.
Housing.
We have already paid, yes. And under RNB, only in Twinsan Division we have paid. But for the rest, we are yet to pay. So I may be given some time to get further
Any
instructions.
instruction from your clients they have received?
Yes,
The
my lord,
housing.
I'm allowed to place the earlier court order, Your Lordship. In 1IA. Your Lordship, here in this case, Your Lordship, the main rate petition was disposed on 23rd of March 2023. And then this honorable court is granted 3 months to complete the court order. After that, I filed a contempt petition. Contempt petition was pending to file one another IA.
Yes.
That is the order which I've placed before Your Lordship. May I go through the last page 8. The second paragraph. The learned additional AGA submitted that the process for verification of work charge employees is going on and will be finished within a short period of time. The learned counsel for the opposite party submitted that the state is already taken a very long time to implement the order of this court, and therefore the state should be given time extension for the last time. That was their prayer. And then on the last second paragraph, the state is given 6 months time to implement the order dated 23/3/2023 passed by this court. No further chance shall be given to the state respondents. And then as of the day, it's about to be 24 months. That's more than 2 years. 2 years, 2 months.
No,
This
actually, in contempt, the law is that even substantial compliance
Lordship.
is enough.
6 months was granted.
That
And then now,
housing, it's all done. For
Housing, yes. Housing, all
No,
done,
Lordship.
yes.
I've connected with the petitioners. Chunsang RNB division, they have paid. Housing, not even a single division has been paid. There may be some miscommunication from the department.
No, I have been instructed from the concerned officer that housing has been paid. And even the chief secretary also has the same instruction.
In this situation,
Housing
Lordship,
has been paid.
Get some documents.
Yes, yes. So for that matter, kindly grant me some time to
Since
get,
there's some dispute.
yes, instruction.
direction may be given to file appropriate documents.
Yes, yes, you file by way of affidavit,
Okay.
the compliance.
Mhm.
Mr. S. Walling, learned counsel for the petitioner is present. So, Ms. V. Shukri, learned counsel, appearing on behalf of respondent number 3 and 10, and Mr. N. Nangami, appearing on behalf of respondent number 1, has submitted that in compliance of the direction of this court, all the employees of the petitioner association who are serving in the housing division has already been given the scale of pay.
No, time-bound
or
scale of pay.
Given the time-bound scale of pay. So however, as far as the R&B division is concerned, R&B divisions are concerned, only the division of Tuinsang only the employees of the Tuinsang division have been paid. So accordingly, it is prayed that some time may be granted to obtain proper instructions and to file an affidavit to that effect. So prayer is allowed, at least the matter after summer vacation.
Yes.
After summer vacation, and before the next date, the respondents shall file their compliance affidavit.
Much
Pleasure.
For motion from the supplementary cost list, item number 22, along with unlisted motion, item number 23.
Too many IAs.
Yes,
What is this?
my lady, the first IA, my lady will take up that IA 91. Yes, I filed this for condonation of delay of 107 days in preparing the connected IA, that is IA 90, that is for restoration. My lady, in the connected appeal, it was last listed before this honorable court on 28/1/2025, whereby 28/1/2025, whereby due to overlook, it was missed out. And it was dismissed as non-appearance. And
On 28/1.
yes. However, my lady, by the order dated 10/12/2024, this honorable court directed the appellant to file an additional affidavit showing the reasons for condonation of delay in the main appeal. So it was filed on 22/1. However, on 28/1, I could not appear due to my oversight, and it was dismissed for non-appearance. And for restoration of the main appeal, I have filed this delay condonation as well as another IA before my lady.
So this 91 is
Is
for
delay condonation.
delay continuation for the
In-
main appeal.
Yes, for restoration. The reasons are explained at paragraph number 5 of
Enough that you should notice. Cannot condone without reading the other section.
my lady. On the other hand, in the main appeal also, I have taken steps, but none appeared till now. And the urgency in this case was on coming 25th of this month. The trial court has issued notice that on the coming date, if the insurance company, I mean, the execution amount is not paid, then property of the insurance company will be attached. So it is a public domain. So unnecessarily it will be, I mean, the insurance company will be harassed.
On which date?
On 25th of June.
25th of June.
Yes, I have annexed the notice as well as the order of the trial court in unlisted motion, that is IA 92, annexure 1. Page number 11 and 12.
The respondents are from Nagaland or where?
No, my lady, the respondents are from Assam, that is from Moriani district. Sorry, from Jorhat district.
So even in the main appeal, they were not appearing.
They were not appearing. Notice was sent already. And by the by,
Deemed served. Notice deemed served.
I'll just check it.
That also has to be seen, unless it
Yes.
is deemed served by the court.
No, it was not deemed served.
Then in
I
that
have
case-
taken steps twice, but paper publication was left. Only that part was left. And by the by,
Then before that, the court cannot go for deemed served, no?
yes, but if my lady may just stay the proceedings of the execution case, seeing the urgency. Because otherwise unnecessarily the insurance company will be harassed for no fault of theirs.
No, but 91 is only for delay.
91 is for delay.
And where is your stay?
Stay
application.
stay is the unlisted motion 92. 92 IA 92.
That will take up then.
Okay.
After this, first we'll issue notice in this
Okay.
delay.
Okay.
This is IA 91. 91. This is an application under Section 5 of the Limitation Act 1963, bring for condemnation of delay of 107 days in filing the IA application number 90 of 2024. Stop.
2025, my lady.
Here you have written 2024.
I'm sorry.
A 90 of 2025. Stop. Heard learned counsel for the petitioner, Mr. V. Debnath. So, it is the case of the applicant slash petitioner that the respondent number 1 and 2 as claimants had filed the claim petition under section 163A of the MV Act 1988 before the MSCT Mokokchung, Nagaland, being MSC case number 40 of 2018, claiming compensation on account of death of the deceased late Raghu Konwar, RAGHUKONWAR, in a road traffic accident. Stop. In the said claim petition, the applicant herein was impleted as party respondent number 1, 2, and 3.
Yes.
Stop. Next para. The applicant entered appearance in the claim case and filed his written statement and denied its liability. Stop. The learned tribunal passed the impugned judgment and order dated 16/10/2023, holding the applicant insurance company liable to satisfy an award of rupees 23,59,800 and interest at 7.5% per annum with effect from the date of filing of the claim petition till realization of the award. Stop. Against this judgment and award dated 16/10/2023, the applicant herein had preferred MSC appeal number 8 of 2024. Stop. However, the same was dismissed, isn't it? However, the said appeal was dismissed on 28/1/2025 for non-appearance of the applicant slash appellant. Stop. It is stated that the dismissal of the appeal on 28/1/2025 was the result of an unintentional oversight on the part of the applicant's counsel, who failed to notice the listing of the matter in the cost list for that date. Stop. As a result, neither the appeal nor the connected interlocutory applications could be addressed, leading to dismissal for non-appearance. Stop. It is also submitted that the absence of the applicant was not deliberate nor attributable to any fault or negligence. Stop. It was only upon reviewing the case status online that the applicant's counsel became aware of the dismissal of the MSC appeal. Stop. Thereafter, he applied for a certified true copy of the dismissal order dated 28/1/2025. Stop. Next para. That the prescribed period of limitation in filing the restoration petition being 30 days with effect from 28/1/2025, it has expired on 28/2/2025. Stop. The instant application was finally filed on 18/6/2025, thereby causing a delay of 107 days. Stop. It is therefore prayed that the delay of 107 days may be condoned. Stop. Issue notice to the respondents 1, 2, and 3. Returnable within 4 weeks. Stop. The applicant/appellant shall take steps by registered post with AD and usual notice within a period of 3 working days from today. So please after 4 weeks. Then IA 92. And what is 90?
90 is the restoration for restoration. Actually, it would,
Okay.
it to have been, the delay ought to have been 90.
Hmm.
But
Yes, this should have been 90.
yes,
And the restoration
yes,
should have been 91.
91, yes.
Then in 90 also, IA 90 also, just say this is an application under Order 41, Rule 19 CPC, read with Section 151 of the CPC, praying for recalling the dismissal order dated 28/1/2025 and to restore the MSC appeal number 8 of 2024. Stop. Issue notice, here also same issue notice to the respondents 1, 2, and 3, returnable within 4 weeks and then steps. Then 91 is?
91 is delay, 90 is restoration, and 92 is the stay of the
Oh,
execution.
okay. This is the extra copy. Then 92 is the stay. Then IA 92, this is IA 92. This application has been filed by the applicant/appellant. In MSC appeal, your MSC appeal number?
8 of 2024.
MSC appeal 8 of 2024. Stop.
Para 5, 6, and 7 are the relevant paragraphs.
It is stated by the learned counsel for the petitioner, Mr. Lee Debnath, that the learned member MSCT Mapukchung, Nagaland, had passed the impugned judgment and order 16/10/2023 in MSC case 40 of 2018, against which the applicant had preferred the MSC appeal number 8 of 2024 before this court. Stop. However, the same was dismissed for non appearance on 28/1/2025. Stop. The applicant herein has also filed another AIA for restoration of the MSC appeal number 8 of 2024. Stop. notice has been issued in the said IA. Stop. However, in the meantime, it is stated that the claimant has filed an execution case before the learned member MSCT Mokokchung, Nagaland, void execution case number 2 of 2024, whereby the applicant insurance company has been directed to appear before the learned tribunal on 25/6/2025 to show cause as to why the order passed by the learned tribunal in MEC case 40 of 2018 should not be executed. Stop. The learned tribunal MSCT Mokokchung has also directed the decree holder to publish the show cause notice in a local newspaper. But there is a technical difficulty. Without restoring the MSC,
Yes.
how can this court pass this stay? See, what you do is you just take these orders and show it to the tribunal saying that you have already filed
Yes.
for restoration. That
Yes.
will serve the purpose and to stay the proceedings there in the execution case.
My lady, with this honorable court's indulgence, if during the pendency of this
Because
notice
as of now,
Yes.
the MSC 8 is no more
is
before
no
this
more.
court. Yes.
Yes. After it is restored, it will come.
After
into-
it's
yes.
restored, it's fine.
Yes.
But as of now, it's no longer there in the before the court. So how can the court stay it now? That is not possible. We will just issue notice, and then you take these copies of the orders and then say that it's already been filed and notice has been issued. That will do. Yes. Yes, last thing. Last thing, what did I say? No, local newspaper. Stop.
My lady, this line in the order that further show cause notice be published in the local newspaper, if this can be stopped by this honorable court. I mean, directing the MSCT not to publish.
That is also difficult. As of now, this court cannot enter into the MSCT at all, and into the MSC case at all, before restoration. So, therefore, it is prayed that the execution case, therefore it is prayed that the further proceedings in the execution case number 2/2024 may be stayed pending restoration of the MSC Appeal 8 of 2024. Stop. Next one. This court is of the view that at this stage, the court cannot issue any such directions in this IA, as the main MSC Appeal 8 of 2024 is yet to be restored. However, necessary orders will be passed if and when the main, even when the MSC Appeal 8 of 2024 is restored to 5. Stop. Accordingly, issue notice to the respondents, returnable within the same list of the faults. See, what you do is you take these orders and show it to the judge, saying that you have filed for restoration. Yes.
Obliged. For hearing, item numbers 6 and 7.
Department. Ready today?
Yes, my lord. May I please, Lordship.
Yes.
My lord, here, all the other parties are heard, except my part,
Okay.
which is remaining.
WPC 154.
154, yes.
Then what is this other one? WP 214.
Yes, my lord, this is tagged with the first read petition, more or less a similar matter. I'll be making submission on that.
Yes, I remember.
My lord, I'll make my submission very short. Allow me to read three paragraphs.
You have filed
Yes.
affidavit.
Yes. I'll just read out from my affidavit, three paragraphs.
Mm.
The affidavit in opposition filed by respondent number 5.
Respondent 5.
Respondent number 5.
Government is also party here.
Yes.
Government submission also done.
Yes.
Okay. Respondent number 5 is.
Allow me to read from para 13. I'll just read three paragraphs, which is page 7, para 13.
Yes.
That with regards to the statements made in paragraph 14 of the writ petition, it is stated that since the Tsami villagers had a habit of damaging properties of Chizami villagers even in the past, although not under dispute, the Deputy Commissioner convened a joint meeting of the two villages on 30/5/2019 in the office of the Deputy Commissioner, PAC, and instructed both the villages that during the pendency of the forest land dispute, no persons or groups should hinder or stop any villagers from cultivating any field if the same was being done earlier through traditional arrangements. The intent of having such meeting chaired by the Deputy Commissioner PEG is that the Tetsumi villagers should not repeat the destruction of wet terrace field or its groups, which has been traditionally practiced since time immemorial by the Chizami villagers. Such orders still stands as neither of the villagers had challenged such orders or instructions or directions issued by the Deputy Commissioner PEG. Next, para 14. Statements made in para 15 to the writ petition. It is stated on that on 8/12/2021, some of the Tetsumi villagers had collected some pine wood logs from Chizami village forest and brought to a sawmill in Chizami village. On inquiry, the Tetsumi villagers denied that such forest products was from Chizami village forest. The article was seized by the Chizami village youth. As usual, on 13/6/2022, the Tetsumi village had once again damaged the paddy fields, crops, nurseries, irrigation channel, and field huts belonging to Chizami villagers. Such destruction of property is not part of the disputed subject matter because the disputed is only confined to forest land at Zilli mountain range. To prevent breach of law and order situation, the Deputy Commissioner PAC had issued the restraining order. Subsequently, by another order number such and such, dated 19 November 2022, issued by the Deputy Commissioner PAC, while revoking the restraining order dated 13/6/2022, the Deputy Commissioner had directed both Chizami and Tetsumi villages to uphold the point number 6 of the minutes of the meeting held on 30/5/2019, that no person or group should hinder or stop any villagers from cultivating any field if the same was being done earlier through traditional arrangements. 15. Para 16 to the writ petition, the deponent denied that after 13/6/2022 incident, Chizami village had never attempted to intrude or trespass into the land of Tetsumi village. This is nothing but a cooked up story of the Tetsumi village. It is also denied that the Chizami village approached the additional Deputy Commissioner for retrieval of their purported grievances. Such allegations are baseless without any material evidence. It is nothing but their own imagination. The summons issued by the LDC Fotoro to both the Chizami and Tetsumi villages were in connection with the incident that happened on 13/6/2022, whereby the Tetsumi villagers had carried out the destruction of the paddy field, horti farms, and other properties of Chizami village, which do not form part of the subject matter of the disputed forest. Both villages appeared before the LDC Fotoro, and after hearing from both the parties, the ADC Futsuro had come to the conclusion that the property damage caused to the Chesami villagers by the Tetsami village was illegal, as the action of the Tetsami village was not the property over the disputed forest between the two villages. The destruction committed by the Tetsami village was over the wet terrace field, which does not form the subject matter of the forest dispute. Thus, after due notice to both the villages, after giving fair opportunity of being heard and on careful spot verification carried out by the district administration, the district administration had come to the conclusion that it would be proper to pass the order dated 15/7/2022, which is under challenge, directing the Tetsami village to pay a sum of rupees 12,25,050 rupees to Chesami villagers as compensation amount. Hence, it can never be termed as fine imposed upon the Tetsami village by the district administration. It is also pointed out herein that another order dated 15/7/2022, the Chesami village had also been directed to pay a sum of rupees 2,72,863 to the Tetsami village for the seizure of 93 pine log on 8/12/2021 from the Tetsami villagers. To that effect, the Chesami village had already complied the order of the district administration by paying the amount through ADC Futsuro. So, my lord, here, the incident, if we are to go back to 1921 incident and start from that story, the matter won't end here. But this
No, and that is already an issue
Yes.
before the civil.
Yes, civil suit, sorry, no. Civil suit 17/3 of 1988 is pending. That is pending. And with regard to the present issue, that is the issue of 13/6/2022, the respondent village, that is the Chesami village, has already filed a title suit, whereby in that title suit, we are claiming for the damage compensation also. So that is numbered as title suit 1 of 2022.
Oh,
Yes.
for this particular.
Yes, for this particular
damage.
incident,
For
for this
this
particular
particular
incident, the Chesami village has already filed a title suit, which is numbered as title suit 1 of 2022, whereby that the respondent villagers, that is the Chesami villagers, are claiming compensation, damage compensation also. So this matter, without going into the merit, if this matter can be disposed of by directing the parties to adjudicate before the civil court. Because both
That's
the
why I was
matters,
thinking, because on what basis the DC is calculating these damages?
Yes.
And DC is not the appropriate authority.
yes,
ever.
yes.
So if that's what I was thinking, that the Chisame villagers should file a suit for
Yes.
compensation damages. So if it's already filed, then.
So yes,
Yes.
so it is my submission that if the parties are directed to adjudicate both the matters before the civil court,
That
that
one
will
is
suffice.
title suit.
Title suit 1 of 2022.
1 of 2022. It is there, no, in the pleadings. It is stated, title suit 1 of 2022.
Yeah, that's-
Title suit is not there because it was filed after the petition.
Yes.
After filing of this petition. Okay, title suit 1 of 2022 before.
Before the district judge, Kohima Lodge,
Civil judge,
district judge, yeah.
district judge.
District
Peg.
Judge
Yes.
Peg.
Kohima Lordship.
No. The title suit is pending
No.
before.
That because now it appears that there are
Two.
two suits.
Yes.
So
One
one
is
is
civil
civil
suit.
suit 17/3 of 88,
Yes.
which is still pending.
Yes.
That is regarding the boundary issue.
Boundary issue. Yes.
Then the other one is title suit 1 of 22
Yes.
before the district judge Peg
Yes.
Regarding compensation, Lodge.
for compensation regarding this issue.
Regarding this issue. Yes.
Issue, Lodge.
Just for clarification, my lord, the civil suit 17/3 of 1988 is tried before the civil judge Kohima.
This one
It
is
has,
in
yes,
Kohima.
it has been transferred. Yes.
Civil judge senior, na? Civil judge
District
senior or
judge.
junior?
District judge.
No, Kohima one,
District judge.
district judge.
Yes.
Then we will pass directions in that line. And then what about 2214?
This 214, the first writ petition 154 was filed challenging the order passed by the additional deputy commissioner. Thereafter, that very complaint was transferred to the referred to the Topashi by the deputy commissioner. That is how this has been
okay,
challenged.
that's why we have
So
said-
this is more or less of the same issue.
No, but how can the Dobashi take it up when the civil suit is already
Yes,
pending,
Your
isn't it?
The first civil suit is different. The first civil suit is different. The 17.3 of 1988 is, that is with regard to boundary,
Oh,
with regard to boundary.
okay, okay. No,
And the
this is
present
very
issue,
confusing.
the present issue is different from that boundary issue again. That is how we file title suit again.
Lordship, why the second second petition was filed was because in the first petition 54, this ADC order imposing compensation was challenged and it was stayed also, Your Lordship. So they were aware of that. Even after that, they referred the complaint before the Dobashi, Your Lordship.
Yes.
They could not have, the ADC could not have referred
Referred
the
it to the
yeah,
Dobashi.
because it
Yes.
was pending here, Your Lordship,
Yes,
and it was
yes,
stayed also, Your
yes,
Lordship.
yes, yes.
So, Your Lordship, the 15/7/22 was by
So
ADC.
here,
Yeah.
in 214,
Yes, Your
what the impugned notar is, that
We have impugned the summon issued by the
Summoned and
Tobashi.
in this case, Your Lordship.
and also the
Case, Your Lordship.
case referenced by the
case
deputy
referenced
commissioner.
by the
And we have also prayed for
Dismissal of the missed case, Your Lordship, which is before the Tobashi, Your Lordship.
Okay.
The prayer portion is at page 23, Your Lordship, of 214. Page 23,
Page
23, Your Lordship.
23. Majority one such and such, something. This is caution set aside the summon. And since the entire issue is in the civil suit 17.3 of 88.
Yes, Your Lordship. So, Lordship, the ADC order and the summons and the missed case has to go, Your Lordship.
Alternate counsel for the, this is WPC 154, okay. Alternate counsel for the petitioner, she is Imumi. Then just put all your names. And alternate counsel for the respondents, Mr. Takakichu. Ashipri Takakichu, who? It's your case or Ashipri's case?
my senior's case.
Okay, you just put Ezo Takakichu. Hearing is concluded
Mo Imjin appeared for the state respondents.
and point for the state respondents. Hearing is concluded and judgment reserved. And in 214 also same parties.
Same parties.
Same parties.
Much obliged.
Much obliged.
For hearing, item number 14.
Maybe this is a short meter. As your lordship is aware regarding the appointment of landowner.
Landowner.
Yes, Lordship. Lordship, here,
I was in the principal seat, I was sitting with Justice Manish. And he was saying, I don't want to hear compassionate and landowner matters in Kohima. Yes.
Lordship, the scheme framed by the state government is at page 14, page 1.
Yes, yes, the 2018 scheme.
2018 scheme. And Lordship, I am aggrieved by Lordship, by not complying with the provision of clause 3B.
3B.
Yes, Worship. Worship, it says that if there's an oral agreement, the concerned department has to forward the matter to the
Deputy Commissioner.
Deputy Commissioner, and Deputy Commissioner has to carry on the verification. That was not done in a present case. That should the facts.
And then why are you challenging the appointment of
Worship,
private respondent?
yes, Worship. Worship, I have submitted in my candidature against the vacancy caused to the retirement of one incumbent at Mokchung in the office of the additional director put in civil supply Mokchung. And my application was not considered in the private respondent was appointed. I'm challenging on the ground that the private respondent was appointed without any selection process. That is also another ground. Worship, for the facts, Worship become the paragraph 4. May I read this on the short paragraph?
Yes.
That the office of the respondent number 3 was constructed upon the land donated by three land owner family from Atsung Changar clan of Mokchung village. The next is very important. The Atsung Changar clan consists of descendants from three grandfathers, namely Tungbang Nok, Moa Sangba, and Chumbung Sangba. Though they belong to the same clan, it is a practice from their forefather that the three family members own their respective land. The present rate petitioner belongs to the descendants of Tungbang Nok. The aforesaid plot of land was donated to the state government without any compensation, with an oral agreement that landowners candidate will be considered for appointment to create for both as and when vacancy arises. This is the basis of my claim, Worship. Should become page 16. This is the application submitted by me, Worship. One vacancy arose due to the retirement of one Sanjit Tamse. He was holding the post of skilled man. And that Sanjit Tamse retired from service with effect from 1/2/2020.
Okay.
So against that
you apply.
against that vacancy, I submitted my candidature. And page 17 is a recommendation issued by the Atsung Changar clan of Mokchung village. And it should become the page number 18. My application was forwarded by the Assistant Director of Port and Civil Supply Mokchung by this letter dated 6 January 2020. It's a short paragraph just to show that my claim was submitted on the basis of land ownership. With reference to the service stated above, I have the honor to forward herewith an application received from Sri M.D. Kamsak, that is a petitioner, on land ownership claim to for the post of skillman under this establishment against a vacancy due to the to be created on retirement of Sri Sanjit Tamse skillman. And Worship, my application in the next annexure, page 19. Upon receipt of my application, the additional director, he has forwarded my case to the state government. However, Worship, without considering my case, Worship, page number 20. The state government have conveyed their approval for appointment of the private respondent. This is a letter dated 23/3/2020. And Worship, if you see in the bottom, the note, please forward to government that prayed for claim by the landowner. This is a remark given by that from the directorate.
Remark by the director.
From the directorate. Accordingly, they wrote a letter also. It should become the page number 21. This is a letter dated 16 September 2020 to the Commissioner Secretary, Worship. May I read?
Yes.
With reference to government approval letter number dated 23/3/2020, that is a government approval letter, regarding approval for appointment of Sri M.D. Sanan to the post of Scalman, Vice Sri Sunny Tamsi, Scalman retired under ET's additional director supply Mokchong. I have the honor to state that this is a case of landowner's right. Worship. Here, the department, they have already taken into consideration that I'm claiming on landowner's right. When grade 4 boss is claimed by the landowner, as the office building falls under the jurisdiction of Asungchang clan of Mokchong village. And this office has already forwarded an application in respect of Sri So-and-so, son of So-and-so. Landowner, along with related documents, like this office letter number So-and-so. Further, as per the, this is important. Further, as per the documents forwarded to the government in respect of Sri M.D. Sanan, that is a private respondent number 4. His date of birth is So-and-so, which is an overage case. And therefore, application in respect of Sri So-and-so, along with the approval letter of the government, is forwarded for favor of information with a request to review the case to avoid further complications. So by this letter, it is apparent that the state government, they are also aware that I'm claiming for appointment on the land of, on the basis of land ownership. So my case is ownership. When I'm claiming for appointment on the basis of land ownership, this was in the year 2020. The scheme was framed in the year 2018. So they should have resorted to this provision. That was not. That is my case. And in spite of this letter also, the state government, they have not considered my case. Thereafter, on the basis of the approval letter, which was issued in the year 2020 by immune appointment order, that is at page number 32.
The private respondent was.
Yes, private respondent was appointed. He is not a landowner. And without any selection process. Well, by this appointment order in the year 2023, 13 January 2023, he was appointed. So I'm challenging this. That is
What
my
does the
case.
government say? The affidavit.
Government is saying that the one of the candidate from the landowner family has been appointed. So appointment cannot be issued in perpetuity as per the scheme. That is your case. But my claim is, as your lordship knows, in spite of the Atsungchang clan of Mokchong village, lordship, they are from the descendants of 3 forefathers. They own separately. That is my case.
In that case, in other writ petitions, the court has directed for an affidavit by the state government to give a list of the landowners who have been appointed.
Lordship, they have an next appointment order. One person has been appointed.
Yeah, please, the lordship. Lordship, here I'm for respondent number 1, 2, and 3. Lordship. And this affidavit is filed on behalf of respondent number 2 and 3. Lordship.
Okay.
Lordship, more particularly, we have stated in the paragraph 3, 6, 7, 8, and 9, Lordship, of this affidavit, Lordship. However, Lordship, before going into the merit of the case, Lordship, we have categorically stated in the paragraph 3 with regard to the preliminary objection for the non-joinder of the necessary party, Lordship. Lordship, here, the necessary party is the Deputy Commissioner of the concerned district, as well as the land revenue. Land revenue, who are the competent authority, Lordship. As far as the notification is concerned, Lordship may kindly come to the notification, Lordship, which has been annexed by the petitioner, annexure 1 of the writ petition, Lordship. Lordship,
Clause
more-
3B.
Yes, more particularly clause 3B, Lordship. Lordship, here is stated that, if I'm allowed to read, Lordship, 3B, Lordship. If there is any claim for providing employment as a result of oral agreement the department concerned shall refer the matter to the Deputy Commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply order, has been given in the past. Written statement from the witnesses, that is government officials of the concerned department and the district administration and village functionaries present at the time of such oral agreement should be taken by the deputy commissioner. The recommendation of the deputy commissioner should be referred with relevant documents to the Department of the Land Revenue for advice in such cases by the department concerned, Lordship. This exercise has not been done, Lordship. They have annexed one, Lordship. They have invoked this notification, Lordship. This is a notification of the government, Lordship. However, this 3B is not being complied, Lordship. Lordship, they are saying that they are the landowner, Lordship, but there is no such agreement, no agreement as such, Lordship. So, Lordship, if there is no agreement as such, Lordship, if there is an oral agreement, Lordship, it has to be verified by the Deputy Commissioner of the concerned district, and thereafter the matter has to be referred to the Land Revenue, Lordship. That is not done.
That is not very fatal, because if the department concerned is a party, then the department concerned can also be directed.
Lordship, in
to
that
consult
case,
the
Lordship, if the department concerned fought my case, if the district administration failed to conduct the verification, in that case, they are a necessary party.
That's right. The department concerned is the
Lordship,
responsible person.
and secondly, Lordship, that is also in contravention with the section 3C, Lordship. 3C, Lordship, if I'm allowed to.
That perpetuity.
3C. It is also clarified that it is not a policy of the government to provide employment to the landowner in perpetuity, Lordship. In fact, Lordship, here is a case where the landowner, initially the landowner has been appointed on land ownership basis, Lordship. Here the stand of the state respondent is that namely one private respondent was appointed, since he was also one of the local residing in that particular area, Lordship, constituency, Lordship. Lordship, that I have mentioned in my paragraph. In my paragraph 8, Lordship, if I'm allowed to read paragraph 8, Lordship, page 6 of our affidavit. That with regard to the statement made in paragraph 6, 7, and 8 of the writ petition, the deponent is in receipt of the petitioner's application for appointment on land ownership basis, along with all the relevant documents and extra so-and-so of the writ petition. Accordingly, the matter was thus forwarded to the Commissioner Secretary, Department of Food and Civil Supply. Subsequently, by impugn approval letter dated 23/3/2020 was received, and thereafter by notification dated 13/1/2023 was issued by appointing Sri Imtisanen respondent number 4 as scaleman against the retirement of Sri Saint Temsu scaleman at Mokokchung headquarters under ADS office Mokokchung. It is also to state herein that similarly situated candidate, namely Sri and Saint Temsu of Chuchuyempang village, a local candidate was also appointed against the retirement of Sri Lanutoshi Ao in the year 1987. Therefore, as a local candidate, Sri Inti Sanen respondent number 4 was also appointed by following the due process of law. However, be that as it may, the petitioner clan has already been appointed on land ownership basis. Therefore, the petitioner cannot claim appointment in perpetuity, Lordship, which is in contravention with the section 3B of the said notification, Lordship. Lordship, therefore, Lordship, my humble submission before this honorable court is they have already claimed their appointment on land ownership basis, Lordship. And now, if they are again before this honorable court claiming appointment on land ownership basis, which will be in total violation, total contravention of the notification dated 5 March 2018, Lordship. And Lordship, in fact,
show how the other landowner was appointed. His appointment order and then his recommendations by the landowner and all that. Page 12, annexure C.
Annexure. We have
Your lordship, in my affidavit, I have.
In the government affidavit also is also with this one Puna Sangba, isn't it?
Yes.
Then that is page 11, 12. Page 12. This is to certify that Mr. Puna Sangba such and such is one of the landowners.
Page 14 will be relevant. 14 and 15. Lordship. 14 is the approval. And 15 is the order. And 16 is the type copy. Petitioner in the writ petition, paragraph 9, Lordship. Paragraph
petition.
9 of the writ petition. Page 8, paragraph 9.
Yes.
Paragraph apology, my lord, paragraph 7. Lordship. Page
Paragraph 7 of the petition.
Paragraph 7 of the petition.
Yes.
Here the petitioner is saying that the private respondent is overage, Lordship. If I'm allowed to be, that the petitioner states that respondent number 2 by which letter dated so requested the state government to review the government approval dated 23/3/2020 on the ground that the post is claimed for landowner, which has been forwarded along with all related documents by letter so further the respondent 2 has stated that in the same letter that the documents forwarded by the government in respect of respondent number 4, his date of birth is 18/3/1985, which is an overage case. Lordship, in fact, we are not disputing with the age, Lordship. However, Lordship, there is a office memorandum dated 15/10/2024 and office memorandum dated 28/2/2022, Lordship, which I have annexed in my affidavit, which in our affidavit annexure H and I, Lordship. Lordship, may kindly come to annexure H and I.
That
Page
relaxation.
Relaxation, Lordship. And that I have categorically stated in the paragraph 9 of our affidavit, Lordship. Page 7.
The approval was issued in the year 2020. Relaxation was issued in the year 2022 and 2024.
After the appointment. Relaxation has to be made at the time of appointment. So your ground is that 3C of the OM. Okay, well, this 5 minutes, we'll come back after 5 minutes.
That is the only ground. That is the only. Yes.
Yes.
Yes, the learned government advocate has taken your lordship to the facts which are very simple. As per the standing government notification, it is very clear. Landowners are entitled to only one appointment. So here, in this case, the present respondent has filed an application for under the RTI and some the reply was, the information was furnished, which is at annexure A of my affidavit in opposition.
Annexure A.
Yes, annexure A, 22nd of April 2024.
Wait, your affidavit is filed on 22nd January, no,
11/6. On 11/6/2024,
R4.
filed on 11/6/2024.
Oh, yes. R4.
Yes. Now, obviously, with the application submitted by the person concerned, and then the certificate issued by the landowner plan, and then the forwarding and appointment order is at page 11. (2018). 26th October 2018. So his appointment with this appointment is on landowner basis against the same office establishment which the present petitioner is claiming. Now the petitioner has sought to bifurcate the clan into 3 groups and all those things, but then the notification is very clear. Landowner appointment, if there is clear agreement, only one appointment is to be considered. The rest, that means the vacancy which arose was not meant for the landowner candidate. So accordingly, on the basis of that, on the basis of the notification, the present respondent was appointed, Your Lordship.
But respondent is not the landowner.
No, he is not a landowner, but my case is that.
But you are saying that
Yes.
since landowner
Since
is already
landowner has been
appointed.
appointed, then I have a right to be considered against subsequent vacancies that arose. That is my only humble submission.
Lordship, against the affidavit in opposition filed by the state respondent as well as the private respondent. Lordship, I file and reply. And if the issue here, it solely reads upon clause 3C, 3C only, Lordship. In the read petition also, Lordship, I've stated that the Atsung Shangar clan consists of from the descendants of three forefathers. That is my case in the read petition also.
This court has dealt with many cases like that. They claiming three, four forefathers, this
Yes,
and that.
Lordship. And Lordship, in my affidavit in reply, I've stated that this Puna Sangba, who was appointed earlier, he's a descendant from Mua Sangba, from the Mua Sangba.
The deponent is a descendant from such and such. And this Puna Sangba is from.
From Mua Sangba clan, from the descendant of Mua Sangba. This is a reply which I filed. Whether they are from the same forefather or from different forefathers, all that will come that will come to light only during the course of verification.
But how do we cross this hurdle of 3C? Because there it says it's limited to the person first appointed as landowner.
Yes, Lordship. But Lordship, as I've stated in my read petition, this is a vast plot of land. In the entire land, it belongs to the three grandfathers. Not only the land does not belong only to the Atsung Changar clan. It belongs to maybe it belongs to other clan also. During the verification only, all that can be ascertained.
But because of all these problems, this scheme was brought out.
But as I submitted my candidature on the basis of land ownership, in that case, I do the department should resort to that to conduct a verification. The issue came up in the year 2020. State memorandum notification was issued in the year 2018. When the issue came up, the notification was there. But the state respondent, they failed to.
No, the fact that you are also one of the landowners, that is not disputed.
That is not disputed.
That is not disputed.
And the main issue is the private respondent, he was appointed without any selection process. That is the case.
No, but the question will be whether you have the locus to challenge.
I have the
us.
locus. But when just need dispute regarding the land ownership, my land ownership.
Any more after this? No. Legal counsel for the petitioner, Shri Limawaba, comma. Learned counsel, government counsel, Mr. V. Zumomi for the respondents, and Mr. Dongpok Pomoner for the respondent number.
Four.
Hearing is concluded, order is.